Welcome to meeting number 90 of the House of Commons Standing Committee on Justice and Human Rights. Pursuant to the order of reference adopted by the House on June 21st, 2023, the committee is continuing its study of Bill C-40, an act to amend the criminal code to make consequential amendments to other acts and to repeal a regulation, miscarriage of justice reviews. Today's meeting is taking place in a hybrid format pursuant to standing orders, and I have two members attending remotely using the Zoom application who are familiar with the processes of committees. Je tiens à vous souligner que les tests ont été effectués avec succès.
The audio tests have been completed successfully.
We have from the Department of Justice, Madame Julie Besner, avocate conseil, secteur du droit public et des services.
Miss Anna Decker, Senior Counsel, Deputy Director, Public Law and Legislative Services Sector, and Julie Besner, Senior Counsel.
Of reference of Wednesday, June 21st. We are debating Clause 3. We are now resuming debate on C-40 and resuming debate on Clause 3, NDP 1. This has already been moved. If NDP 1 is adopted, Liberal 1 cannot be moved due to a line conflict. As the House of Commons Practice and Procedure 3rd edition states on page 769, amendments must be proposed following the order of the text to be amended. Once a line of a clause has been amended by the committee, it cannot be further amended by a subsequent amendment, as a given line may be amended only once. We will resume debate, and Mr. Housefather, the floor is yours.
Point of order.
Yes?
Madam Chair, Mr. Fortin is not here. At the end of your opening statements, he always asks if the people remotely have had their sound check and if it was successful.
I said it was, but I said it in French,
I know,
so
but
apologies if you didn't understand
it. Whether you say it or not, he tends to ask. So
sometimes
on his behalf, I'll ask.
Rappel au règlement, Madame la Présidente.
Madame?
Point of order. Point of order, please, Madam Chair. As you mentioned at the beginning, I didn't think that it was necessary to go through the entire explanation again.
Father, before you continue, I simply want to say because this is public for people and for the members, thank you very much for being here today. I know we have extended hours, very, very long extended hours, and I know everybody realizes the urgency of having this bill proceed to third reading. So, again, it's a matter of justice for our country, and we are here to deal with it this afternoon. So, Mr. Housefather, the floor is yours.
Thank you. Thank you so much, Madam Chair. And as I had mentioned at the last meeting, I want to thank my colleague, Mr. Garrison, who I very much admire for his views on justice issues, which I think are very similar to mine. I think that my amendment, Lib 1, is preferable to NDP 1. I think the amendment Lib 1 is structured, they both try to achieve the same thing, which is that somebody who has an appeal to the Court of Appeal may also benefit from the Commission looking into their file should the Commission choose to do so. And what my amendment does basically is it makes clear that someone who has not appealed to the Court of Appeal is treated in exactly the same way as if they had not appealed from the Court of Appeal to the Supreme Court. The Commission would look at exactly the same factors to determine whether or not there was a reason why they should look at that case. So the streamlined way that I have done it in Lib 1 basically treats a non-appeal to the Court of Appeal the same way a non-appeal from the Court of Appeal to the Supreme Court is treated. And I actually think it's a more flexible way and will give more people the option to be heard by the Commission than the way NDP 1 is structured. So while I agree completely with the premise of NDP 1 and the idea that people who have not had the right to the ability to appeal to the Court of Appeal, especially the poorest and most vulnerable defendants, should have the right to have the commission consider whether there are factors that should allow the commission to look into their case. I think the way mine accomplishes it is better. And because there's a conflict of lines and we can't pass both, I will be voting against NDP 1 and for Lib 1, but I just wanted to explain that. Thank you, Madam Chair.
Thank you, Mr. Housefather. Mr. Garrison?
Thank you, Madam Chair. And I guess I remain stupidly optimistic that we could finish consideration of these amendments and finish consideration of this bill today. As I've said many times, there are many people who are among the most marginalized in our country who are currently serving time for crimes that they did not commit, and they're waiting for this commission to get up and running so that they can seek justice. So I'm hoping that today, in the next 2 hours, that we can dispatch this bill and make it ready for the House to consider in the next sitting. What I do want to say about Mr. Housefather is I do agree with him. We're trying to accomplish the same thing, but I think in, I guess, defense of my amendment, what I've tried to do in my amendment is focus the Commission's attention on those who did not appeal, on the reasons they did not appeal, and focus on those reasons that constrain the ability through legal representation, through knowledge, through opportunity, that people didn't have the ability to appeal. I am not intending to make a wide opening to the Commission for people who didn't appeal, who aren't in that situation. And for that reason, I wrote this specifically into the amendment to make it clear that it was the purpose of those who simply didn't have opportunities or abilities, and not simply anybody who failed to appeal. And so I agree with Mr. Housefather that mine is in fact probably a bit narrower, but it's a bit more focused on those providing the right to be heard who had limited opportunities and resources. Thank you, Madam Chair.
Thank you, Mr. Garrison. Mr. Moore?
Well, Madam Chair, I think Mr. Caputo was next, I thought, but my remark was just, all right.
Unless you don't want to. Yeah.
No, I do,
Okay,
actually.
please go proceed.
And I think it's on a point that was just raised by one of our colleagues here, Mr. Garrison, said that there was individuals awaiting who suffered a miscarriage of justice or wrongful conviction who are waiting for this legislation to pass, when in fact it was the testimony of the, I just want to point out so that Canadians are not under a wrongful illusion of what the situation is. There's a robust process that currently has existed over the last 8 years of the current Liberal government, existed prior to that as well under a Conservative government. There is a process whereby someone who has been wrongfully convicted or suffered a miscarriage of justice can avail themselves. Ultimately, the arbiter of the outcome is the Minister of Justice. Minister Virani appeared here and explained the current system. Now, this bill seeks to, Bill C-40 seeks to amend that system, seeks to change it so that it is not the Minister of Justice. We've had a number of ministers of justice who have spoke to us about this, and we've had a number that have dealt with cases of wrongful conviction. Minister Virani, possibly not yet. He said that there are some in the hopper, so to speak, with the department. There's a team of individuals at the Department of Justice who are experienced and specifically tasked with dealing with under our current criminal code, under our current laws, miscarriages of justice. They provide advice to the minister, and that's the way it has been done. There are those that feel that that is inadequate, and there's no doubt that laws can always be improved upon. But I wouldn't want anyone to think that unless this bill passes, the wrongfully convicted do not have a process by which to avail themselves, because they absolutely do, and that should be acknowledged. And that's the testimony of the Minister of Justice who appeared here on this legislation. So I wanted to make that point quickly at the outset, Madam Speaker, that if individuals are somehow waiting for this legislation to pass, individuals who are wrongfully convicted. For example, DNA evidence subsequently shows that they in fact were not the individual who was at the scene of a crime, or new evidence comes forward somehow that exonerates this individual who was arrested, prosecuted, convicted, with the full benefits of the Charter of Rights, with a robust defense. This individual was convicted of a crime. Subsequently, we find out, you know what? The system got it wrong. This individual is not guilty. This individual is innocent. Well, then, there is a process. So nobody in that situation should be waiting for C-40 to pass. To say that we're waiting for C-40 to pass would be to say that we're somehow opening up our system of justice in this country, opening the doors up to allow individuals who are not innocent to avail themselves of this process. Because if someone is innocent, if someone is factually innocent of a crime, there's a process whereby, and ultimately it would be Minister Virani who makes the call, but he, under the advice of an entire team within the Department of Justice, there is a process for that. So I want to, at the outset, before we get into this, state that. And I just thought with the comments from Mr. Garrison, someone could be led to believe that Canada doesn't have a process, when in fact we have a very robust process.
Mr. Caputo.
Pardon me. Thank you very much, Madam Chair. I want to thank our witnesses, Ms. Decker, Ms. Besner. I know that you've been very patient with us. Welcome to Madame Michaud. Bienvenue. And I think that she's our only visitor. Oh, Ms. Thomas as well. Thank you very much for joining us as well. So I think that the dichotomy between the two amendments is an interesting one. And a lot of what we deal with really does come back to the clause generally that we're dealing with, Clause 3, as it relates to the issue of a miscarriage of justice. Perhaps our witnesses, we've both heard what Mr. Garrison and what Mr. Housefather said. I don't doubt they obviously come at this from a very sympathetic and compassionate point of view. And you know, they come at it probably from the same angle as everybody here, which is none of us want to see a wrongful conviction. I have expressed this many times before. I won't get into significant details, but most people here know I was a defense lawyer for a time and a prosecutor for a much longer time. One of the cases that haunts me to this day was it was an administrative case, so not one that would have been considered serious by the public, but one where I really think that the person was not dealt with appropriately by the courts. I would classify it as a miscarriage of justice, and there are all sorts of law society obligations now on my part, even with respect to that file. And you think about it, pardon me, because these things, they absolutely, positively never go away. I've also dealt with somebody who, in the past, again, I won't mention names just due to privacy and confidentiality, who was subject to a wrongful conviction and was
Appel au
properly...
règlement, Madame la Présidente. Je suis désolée, mais...
Point of order, Madam Chair. Now, and in order, rather than avoid, or to avoid, let's say, having to listen to this all afternoon, I think that we seem to have some nasal congestion through the microphone here, and it may be quite disturbing to the interpreters.
Caputo a dit qu'il ne comprend pas.
Can you repeat that in English, Madame Brière? Because Mr. Caputo says he did not hear the interpretation.
I'm so sorry. My volume wasn't up. I'm so sorry. My fault.
Ah, okay.
That's my fault.
Okay.
But I did not, I'm not sure what the point of order was.
Pouvez-vous répéter, Madame Brière? Il n'a pas entendu parce que ça.
I said that it was already awful to have to listen to that filibustering for I don't know how many hours. And if you could please stop sneezing in the mic for us and for sniffling, thank you, and for the translators.
Okay. Yes.
I turned my mic off there. Is there a tissue here, please?
Point of order, Madam Chair. Just, Madam Briere just mentioned the length of time that we're meeting. The normal meeting time for the Justice Committee, Standing Committee on Justice and Human Rights, is Tuesdays and Thursdays from 3:30 to 5:30. So you can imagine we're currently looking at Bill C-40, which, as I mentioned, creates an entirely new commission, entirely new body to deal with wrongful conviction. I don't want anyone to be under any illusion. We're going to take the time necessary to look at this bill. We're going to look at every sentence, every word of this bill, because it all has meanings. It's going into the criminal code. It's part of our duty. But if Madame Briere has an issue with the timing of the meeting or the length of the time of the meeting, I would urge her to raise it not with Mr. Caputo, who did not schedule the meeting and did not set the time, but through you, Madam Chair, she should raise the issue to you, because I received a notice.
So, Mr. Moore, I agreed. It's not a point of order. And
No, it is a point of order.
No.
What is it then? If it's a point about this meeting, that is a point of order. It's dealing with the timing of the meeting. The
Right.
meeting is scheduled from 3:30 to 11:30. But Madam Chair, it's you who scheduled that. So
that
maybe
is
you
correct.
could explain
The
that to
meeting-
Madam
that's
Briere,
correct. The
because she's looking at
not a
us, but
problem.
it came from you.
yeah, absolutely. I did schedule the meeting, and we're here.
Point of
So-
order, could you explain why you scheduled it from 3:30 to 11:30?
To allow members the opportunity to look at each and every clause and be satisfied with the amendments
Exactly.
that were brought
Well,
up.
on that point of
So
order.
now I'm going to move to the next speaker.
No, on that point of order, Madam Chair.
This is the last time.
No, it's not. I can have
Oh,
as
yes,
many
I
point
can.
of orders
Yes,
as
I
I
can.
want. But on this point of order, this committee is a standing committee of this House of Commons. We can meet at our regular scheduled meeting until we finish studies of any number of studies, bills. We had a study on wrongful conviction. We had a study on, with this bill, we had a study on the federal government's obligation to victims of crime. We've passed different pieces of legislation. My point, Madam Speaker, is there is no obligation on this committee, where there is no directive from the House, that we would finish Bill C-40 today. So there's no reason to schedule a meeting for 8 hours straight. So if someone has an issue with the meeting being 8 hours, they should take it up with you, because this committee is scheduled to meet again in the new year, and where we will pick up on Bill C-40, I'm sure.
So thank you, Mr. Moore. Appreciate that. I'm
Point of
now
order.
going to move to the next speaker.
I have a point of order.
Yes, Ms. Thomas.
Thank you. Madam Chair, you just said to my honorable colleague that this would be the last time that you would give him the opportunity to speak. I'd be curious as to where in the Green Book or the standing orders you find permission as chair or direction as chair to.
Absolutely, Ms. Thomas,
I'm not done my
yeah.
point of order. Thank you for being respectful of my time. And so I'd be curious to know why you would rule that my colleague would be cut off, that he would only be able to raise a certain number of points of order or to be able to speak a certain number of times. I haven't read that in the Green Book. I am not aware of that being in the standing orders. I'm quite familiar with them myself, having been a previous chair. And so I'm curious if you can point to the place in the Green Book where we would find that ruling.
So thank you. We've dealt with that last time, and I did point, and I will not entertain it again. I did point to the rule book, and I want to move on now. So I'm going to go.
sorry,
You
point
can
of order.
challenge the chair. I've made my ruling. Please
I
challenge
have
the
a
chair.
point of
no,
order.
you can challenge the chair, and we will have a vote.
I have a point of order.
I said you can challenge the chair.
You're referring to a decision that was made in the past when I wasn't here.
That's not my. If you wish to challenge the chair, I will move aside and we will call this. Otherwise, I am moving to the next speaker.
I just wish to understand why you feel that it's your prerogative as chair to limit the number of times people at this table can speak. There's only a certain number of points of order that we're allowed to raise.
If I can lend a hand, the chair did not say that. She was really trying to move on from Mr. Moore. At no point did she ever say to anybody here today or previously that people were limited to the number of their interventions. She was ruling on a specific point of order and addressing an issue of relevance. It's as simple as that. Let's not waste time and let's move forward.
Like to challenge, do so. Otherwise, the next speaker is Mr. Garrison.
I'm certainly
Well, no,
not.
I think his name was. I thought he was finished. What?
No, I had to sniffle. We haven't even got started yet.
Okay, Mr. Caputo, go ahead. Your name was scratched, so I thought you were done. But go ahead if you're not done.
That's fine. I apologize. Frankly, I sniffle for about 6 months of the year.
Don't worry about it.
It's just something with my biology. I apologize to the translators. If I have to sniffle, I will try to mute myself because the last thing I want to do is harm our translators here. I'm getting a thumbs up, so I apologize. Thank you for your work.
Most people would understand that.
So I'm going to start from where I left off here. Mr. Garrison, Mr. Housefather, I know them to both be conscientious members of this committee, conscientious members of Parliament, and both persons of principle who, though we often will disagree, I think we all would say that we stand fast by our principles. I do not doubt where they are coming from. I think that one of the things I was discussing was that as a defense lawyer, when I was dealing with a matter, it wasn't really necessarily a serious matter in society's eyes, but a matter nonetheless that would attract significant liability before the court, that it's my view that a miscarriage of justice occurred, and that is something that sticks with me each and every single day. Not something I want to relive, because one of the things that we deal with in this committee is that, and perhaps this is even tunnel vision on our part as a committee, or maybe it's just where we get wrapped up, is this. It's so easy to focus on the big cases, and when I say big cases, I talk about people who've been convicted and incarcerated for a great deal of time. Everybody whose day has their day in court, that's a big day. Whether they're there for the first time or whether they're there for the 100th time. It's their liberty that is on the line, and that is important. That's their day. And perhaps for some people, if they've been through it a number of times, it's not going to be the same as the person who walks into trial for the first time. That isn't to say, though, that it's not important. It certainly is. But we frequently hear about people who were incarcerated on life sentences, for instance, where their exoneration came after years on parole even, wherein they had served a substantial amount of their sentence. So that's one thing I just wanted to state for the record, is that when we do consider wrongful convictions, we have to think about this in the grand scheme of it all. Secondly, I don't think anybody here ever would want to see that. So Mr. Garrison and Mr. Housefather bring forward two competing amendments. In my view, they generally do accomplish similar things. Now, we've heard from both of them what they is their interpretation, and I'll be very candid. I'm terrible, like on Lib 1, trying to kind of piece together what exactly it says. I'm not the best guy at best person to look at that and say, okay, this is exactly what it is. Could Ms. Besner, Ms. Decker, could either of you just tell us, please, in your eyes, independently, what is the upshot of each of these amendments, and where are the substantial similarities and differences, please?
Yes, Ms. Besner, thank you.
I'll only comment as to kind of the effect of what the amendment appears to accomplish or its impact on other provisions within the bill. Obviously, it's for the committee to decide if one approach versus the other is the better approach. I was listening a moment ago when Member Housefather was describing his amendment, and I didn't see anything, inaccurate in how he described it. I think that's all I can say. The other day I described very briefly, I was asked at the end of the last meeting to describe NDP 1, and I did. I just identified one potential issue with that it only makes exception to sub 3A and not B. So there's just a question there as to what would happen with B. And that's all I would want
I'm
to say
sorry,
about that.
I'm sorry, I'm not recalling that. Can you elaborate on that, please? I'm just going through here. Can you elaborate on that, please?
So when you look at page 3 of the bill, subsection 4, exception, it currently says despite paragraph 3B. So that means that exceptions can be made when someone has not sought an appeal at the Supreme Court. And NDP 1 proposes to change that to say despite subsection 3A, which applies to when someone has not sought an appeal at the Court of Appeal, and it doesn't speak to what would happen if there was an appeal sought at the Court of Appeal, and then let's say it was unsuccessful, and there's perhaps still an issue that could be raised at the Supreme Court. I'm not sure what would happen if it just says despite subsection A, and it doesn't also include subsection B. Because B right now, subsection 4 canvasses all the considerations the Commission would have to look at in determining whether it could admit an application despite appeals not having been completely exhausted.
I see. This isn't easy, obviously. This is a complex area, so I appreciate you distilling this. I mean, if I had moved such an amendment, I'm not sure that subtlety would have resonated with me. And if you'll allow me for a second, I just want to try to wrap my head around it. So what would be the impact if NDP 1 were to say, despite paragraph 3A or 3B? What would that then do?
The factors enumerated there would apply in both circumstances.
Would that make it more encompassing then?
Yes.
Yeah.
Yep.
One of the things that I don't believe, and I was gone for some of this, for some of the testimony, and I apologize I wasn't here for that, including my former colleague, Mr. Weiberg, who I know was well respected across the country for his work in criminal law. The notion of miscarriage, because here we're talking about appeal and whether somebody should be foreclosed from making an application to the Commission. But one of the things, and perhaps I have missed this, but I believe that there was substantial testimony about this, is the definition of what a miscarriage, what would qualify as a miscarriage. Obviously, that would have to be subject to interpretation. Do either of you have any comment on that?
Yes, certainly. It's true that there is no definition in the code for miscarriage of justice, though it is a term that is used in several different sections, and I would say key sections, not to mention this entire part of the criminal code. Part 21.1 that's being amended deals with miscarriage of justice. It's also used in the appeal provision. So conviction appeals can be presented to the Court of Appeal on either the basis of unreasonable verdict, error of law, or the third ground is any ground on which there may be a miscarriage of justice. It's not defined. The courts have certainly articulated what it can include. I believe I recall the minister also saying that it's not proposed to be defined because it's malleable, and that is intentional, because things can evolve and circumstances can be quite varied as to whether or not something amounts to a miscarriage of justice. I could say that in some of the key cases, it's been things like misapprehension of evidence. It can be prosecutorial or judicial misconduct. It can be tunnel vision. It can be a number of things. And the other thing I wanted to mention about that third ground of appeal, it's a standalone ground. It doesn't have to be like in combination with an unreasonable verdict. And that comes from the Supreme Court in a case called Lower that says that that basket, any ground that constitutes a miscarriage of justice is a standalone ground of appeal.
I'm sorry, when you say standalone ground of appeal in respect of?
Just a conviction appeal doesn't have an applicant would not have to both establish that the verdict is unreasonable and that it's a miscarriage of justice. Miscarriage of justice on its own
I
can
see.
be a ground of appeal.
I see. So
Yeah, or an error of law, for example. It's not like
You don't
that
have
there
to
has to
prove
be a
both.
combination of grounds. It can be a standalone basis to present.
Right. So if I understand your interpretation correctly, an applicant could go before the commission on the basis of this verdict was reasonable on the evidence, but nevertheless resulted in a miscarriage of justice. Is that what you're saying?
It's possible.
Yes. Well,
Yeah.
of course, I suppose that if there's evidence that was fabricated, that the verdict may have been reasonable based on fabricated evidence, but that itself is the miscarriage of justice. Am I making sense there?
Yes.
Yeah. Okay. So, you said something that struck me, and that was we talk sometimes about categories, and I think I don't want to misquote you, but my interpretation of what you said is there are broad categories, and those categories we don't want to foreclose any category of miscarriage of justice, but my view is that generally when we're looking at these things, that there are principles that underlie these things, right? So the principle is that for one principle, somebody should not be convicted for a crime they didn't commit. It's a basic. That's the rule of law. That's one tenet of the rule of law. It's a very basic one at that. That if you didn't do it, you obviously shouldn't be punished. And we were all taught. Even in high school, we would talk about this in my Law 12 class, talking about is it appropriate for one person to go free, or 100 people to go free in order for to prevent that one innocent person from going to jail, or 1,000, or at what threshold do we reach that? My concern, though, is that we don't want to foreclose the categories that could result in a miscarriage of justice, but really, aren't there just a couple of principles that would underlie this? Number one, and I think the main one, and perhaps, I shouldn't say the main one because we heard divergent testimony on this, was that the person didn't commit the offense. That is the most basic miscarriage of justice. So we're looking at, I believe it's the Truscott case, and other cases, Milgard. They didn't do it, right? DNA says that person did not commit the offense. I think we can all agree, classic miscarriage of justice. Now, you've talked about other things, fabrication of evidence. So if the fabrication of evidence, if there's evidence that was fabricated, sorry, I'm just trying to formulate my thought here, I apologize. If we're looking at the fabrication of evidence as it relates to a miscarriage of justice, would this bill look to somebody who may be factually guilty. By that I mean they committed the offense, but they should not have been convicted based on the evidence. In your view, is that a miscarriage of justice?
I don't want to be extremely categorical in answering that, but I could, no, just like, because there could be a lot of factors at play. So for example, or in a general way, a miscarriage of justice is often any new information or evidence that comes to light that calls into question the reliability of the verdict or the process that led to it. So sometimes that second branch or the process that led to it, it could be things like coercion, processes that led to the extraction of a false confession or threats. You gave the example of fabrication of evidence. That's an example. There are also circumstances in the early 90s, for example, there was a broad review that was conducted of self-defense after the Supreme Court came out with its decision in Lavallee. So the battered woman syndrome and all of that. And so there was a lot of cases needed to be examined just to see whether there could have been a valid defense of self-defense that could have been advanced that was overlooked. Those are just, and despite it having resulted in, for example, the death of a spouse. You know what I'm saying? So there could be a variety of different circumstances. So we can't quite be very categorical, but that is as well the benefit we try to describe as like the fact that it's not defined, but the courts have not had any problems that I've observed in my reading in wrapping their minds around the concept of miscarriage of justice.
Well, thank you. And I know these are hard questions, so I apologize, but I find this very interesting, to be candid. So if I have your point correctly, it's, was justice done? The point I made earlier, I guess I would call it factual innocence, if you will. But then you've also got the process of guilt, the process by which a person is found to be guilty, as in, was there obstruction of justice there? Was there any of these categories? But again, those are the underlying principles, right? So that's what the point I was trying to get at before was that when we look at these things and the categories, perhaps it's as simple as that there are a couple of categories here that result in a miscarriage of justice, though undefined. One, the person is factually innocent. Number two, the process by which the person was convicted was flawed in some way. Can we agree on that those are kind of the two categories?
Can I ask you to repeat them?
Sorry.
You just said that, okay, yes, no, I got them now.
You do? Okay.
Yeah.
And I'm certainly open to whatever you have to say on this.
I think you just kind of repeated what I had first articulated about anything that calls into question the reliability of the verdict or the process that led to it. Did you want additional examples of the process that led to it? Is that what
No,
you're
what I'm asking is are there any other categories that you would see that would lead to a definition of miscarriage of justice? Or can we, because what I'm trying to drill down here are the principles that amplify what a miscarriage of justice is.
Well, the description I provided is a bit of a catch-all.
Yes.
And so underneath that, there could be a lot of things that fall into those two broad categories.
Okay.
Yeah.
So would somebody say, reviewing their sentence from 40 years earlier, would and sentencing has drastically changed in how an offense is viewed? Would that itself come to be something that could result in a miscarriage of justice, or could be construed as a miscarriage of justice, as in the sentence at the time was within, let's say it was within the appropriate range. So the judge who imposed sentence did not commit an error of law in imposing this sentence. Now, 40 years later, that sentence would be dramatically different, right? Would that be considered a miscarriage of justice potentially?
I don't want to speculate too broadly on that because I think it's something that the courts would certainly turn their mind to if it came up as an issue in a particular case. I can say that I recall having heard that in the UK, they did re-examine some sentences for individuals where there was no longer an offense, and I think it was like, for example, same-sex relationships from decades ago. I think they did do some kind of review of that kind of conviction and sentence that had been imposed when afterwards the law had evolved.
Right, and I'm not sure if that's, to me, the government, and I can't recall under what prerogative that the government can look at that. There must be a mechanism by which the Minister of Justice can say, look, this was historically an offense. It is no longer an offense. It should have never been an offense. And those people who were convicted of this offense, that is of no force and effect. Is there a mechanism in the law to do so?
Yeah, I believe it falls under the Minister of Public Safety's portfolio for pardons. Pardons.
Okay, for pardons?
Yeah.
Okay. So I thought it was something a little bit different than that, because it's my understanding that the pardon is issued at the individual level, as in the example I was describing, it's that everybody who falls into this category is no longer considered to have committed an offense, whereas a pardon, or I believe they call them record suspensions now, just to confuse us a little bit more. Whereas a pardon or record suspension is provided by the Parole Board of Canada, and the Parole Board of Canada is at arm's length from the minister. And in
Point of order, Madam Chair.
Yes, Mr. Garrison?
Okay, so we had this concern raised before. We're dealing with clause-by-clause consideration of the bill, and much of what Mr. Caputo is talking about has absolutely nothing to do with either the clause under consideration today or the specific amendment we're dealing with. And so I would ask the chair to remind Mr. Caputo that while there are other opportunities in the clause-by-clause consideration to talk about the bill as a whole, this is not that opportunity. This is to talk about the amendment before us and the clause which is under consideration.
Mr. Caputo?
yeah, sure.
Obviously, that is absolutely correct.
Oh, I don't.
We are dealing with clause number 3.
We are dealing with clause number 3 and amendment NDP 1, which also, in my view, incorporates amendment Lib 1. But when we're talking about whether a person has exhausted their appeals, and when we're talking about what a miscarriage of justice actually is, to me, that is germane to every single section in this bill. I'm not sure that we can say that that's not relevant, what a miscarriage of justice is, when every single section in this bill deals with that. So with respect to my honorable colleague, I have to part company on that point. I think it is completely relevant.
So you want to continue with your
Yes,
clause, clause 3, please? NDP
Yes.
1.
So we were talking.
We can read it into the records if that helps everyone.
I'm in the chair's hands.
Mr. Garrison, you want to read your...
No, Madam Chair, I believe it's the responsibility of the members when
To
it's
have
already
read
been
it.
presented to the committee to
So-
do their homework and be here prepared and know what section we're on. As I said earlier, and with all due respect to Mr. Caputo, there is a section of clause-by-clause consideration when we will be asked, should the bill pass, which allows general discussions of the bill as a whole. That is not the purpose of our discussion and debate of this section or this specific amendment. And so I will have some more to say later about this, obviously. Thank you.
That is absolutely correct. When we're talking about generalities, you do have a chance at the end when we are talking about the bill. Right now, we are dealing with clause number 3, so please go ahead.
Yes, I agree. My point is that the generality about what a wrongful conviction is isn't just an issue with the bill as a whole. That is an issue that strikes at the heart of every single clause. So, I have to part company with my colleague on that point. On the issue of pardons, I found that interesting because I believe that somebody gave testimony about that, and I can't recall who it was because they gave evidence about somebody whose life had dramatically changed subsequent to their conviction. And if you want to wrap it into, if we want to really tie it up with the amendment, in that case, the person may or may not have appealed in that case. Let's say they didn't appeal because, in their view, they were factually guilty and they were morally guilty. But 40 years later, 30 years later, they have changed their life. And they've not had a single offense since then. My understanding is that ordinarily a person in that case would seek a pardon, as in the legal effect of the pardon, the precise wording, it escapes me, but it's essentially says though you were convicted, this offense is no longer, you would no longer have a criminal record for this. Did I say that properly in your eyes?
I'm not an expert on the record suspension statute, so I can't quote or lift from the language of that act. I'm sorry.
Okay, I'll assume I'm kind of correct on that for now. So that was something that was a bit confusing to me, was when we had one witness, and again, I apologize because I can't recall who it was, who said, on the one hand, yes, somebody has changed their life, even perhaps somebody who's doing a life sentence. And I can remember people who remember meeting somebody well into their 70s, and you would have no idea that they committed the offense of murder in their 20s. You would have no idea. Completely different person. They've been out of jail for 35, 40 years. They could be your next door neighbor. Now, in this instance, when it comes to the bill, could it be that such a person who has changed their life and would ordinarily be under the record suspension or pardon stream, could it be that this miscarriage of justice would be that this person has that offense on their criminal record or is still doing time for that offense by virtue of the fact that they're under the jurisdiction of the Corrections and Conditional Release Act?
I think all I can add to that is that currently, and I would imagine in the future, as part of the screening process, it would have to be determined whether what's being sought here in an application for a miscarriage of justice review is the proper avenue for the individual to pursue versus under the public safety umbrella, as I described, the Corrections and Conditional Release Act, I think, includes the record suspension regime. And it's like currently, sometimes people are diverted to the other stream if that's really the avenue they should be pursuing, depending on the circumstances. And that's at the initial screening and intake, and I think that will continue to happen with the commission.
Perhaps I'll try to be more direct. We heard evidence at, oops, I'm sorry, I hit the microphone. We heard evidence at committee from a witness who said, somebody in that situation should be able to apply to the commission for a review of their conviction or their sentence based on subsequent behavior. My question is that person, could that be encompassed by the wording that we have here?
I don't believe it would on that short description you provide there.
Okay.
There are admissibility criteria. They are actually in the provision that's being discussed right now. And it has to do with the type of finding or verdict that the court entered, and then whether the individual exhausted their rights of appeal. And there would be other information that the commission would request in the application form. to do an initial screening of the application.
Right.
But I think that it's a separate stream when it appears, obvious on its face that the conviction is reliable and that it's rather just a rehabilitative situation, and they're looking for some kind of reprieve from the effects of their sentence and their conviction. So I don't think that would be this stream, if I got your question clearly.
Okay, thank you. I think you've answered it.
Okay.
Thank you. If I could just have one moment, please. Earlier, an error of law, obviously, as being a miscarriage of justice. If an error of law is committed and there is an appeal, presumably that would have been found by the appellate court. Is that correct? Is there a situation in which an error of law occurred, an appeal occurred, the appeal court got it wrong, and then 30 years later they have a chance to revisit it?
It depends. So again, in the statute, we have the considerations. Is there a new matter of significance that was not previously considered by the court? A new matter of significance can be new information, new evidence. So that is sometimes one of the first indicators that if there's something new that wasn't previously considered, that it may call into question the reliability of the verdict. And on just to distinguish between evidence, and you first launched your question by saying that it was an error of law. There are circumstances where the law evolves, and the legal society becomes more informed of what the law, how it should be applied present day. So evolution in the law is something that could be looked at. Mm-hmm.
Well, I'm glad you said that because, this is going to sound totally nerdy, but I remember going back to my first year criminology class, and I believe Mr. Garrison may have taught criminology actually, 1997 or 1998 at Douglas College. Shout out to Douglas. I still remember first year instructor Trenier, Paquette, Logan, Vaillancourt, Rodney. Those are the 5 cases that talked about, I believe it was intent to kill, and whether you needed subjective foresight, objective foresight, and all that other stuff. So it used to be pre-charter that a person, I don't believe you needed to have any foresight to kill in order to be convicted for murder. I believe the big case was Vaillancourt that changed that. Going back, so please nobody quote me on this, about there had to be some sort of objective foresight. But I'll give an example of people going in. Let's say they went in, to classic example, 2 people have the common intention to rob a bank. They go in there, person A and person B, they both have firearms. Person A commits the offense of murder. Person B was then liable for the constructive, was liable for, I believe it was constructive murder was the term that was used. A person is convicted on that, say, in 1980, at 21 years old. They're now in their 60s, 70s, and out of jail or not out of jail. That person would not be convicted today on that. Is there a mechanism by which that person could go to the Court of Appeal right now to have that conviction quashed based on a change in the law?
I'm aware that there are fresh evidence applications that are made routinely to the Court of Appeal,
Okay.
even if it's like beyond the time within which to normally file an appeal.
Yeah, of course.
With leave. So it would depend on the evidence. I really can't get into big hypotheticals and put that kind of information on the parliamentary record as to that particular scenario you described would fit the bill. It's just not this bill, but fit the description. So I'm
Right.
sorry if I
No, that's
can't
fine.
engage too deeply into.
No, that's fine. I've actually I've wondered this for quite some time. This wouldn't be a fresh evidence application. It's the record says this person had no intention to kill, and they were convicted of murder based on the law, say in 1981, the law in 2023 would never have convicted them for murder, would have been potentially convicted for manslaughter. If that's the case, is there a mechanism by which the person who would have been convicted for manslaughter now, but was convicted for murder then, is there a mechanism by which they can go to the Court of Appeal, or would they need to avail themselves of this type of statute?
Point of order, Madam Chair.
Yes, Mr. Maloney?
I respect Mr. Caputo's experience in criminal law, and I'm grateful for the fact that he's probably the first conservative since we started reviewing this bill that's remotely close to the subject matter, but he has strayed far afield. He's now talking about things that don't even have a tenuous connection to this draft piece of legislation. So I would ask that you request that he move on or get back focusing on the actual language of the bill itself. Thank you.
Can I reply, please, Madam Chair?
No, Mr. Maloney is quite correct.
Well, with all due respect.
Maybe there's other legislations or other committees in public safety to talk about parole boards and so on that you probably, you know.
With all due respect,
Please go
saying whether somebody who committed a crime in 1980 and should have that crime revisited today by a commission for a wrongful conviction based on the fact they wouldn't have been convicted in 1980 is not relevant. Do I have that correct? That's exactly where I was going. It's exactly what I asked, with all due respect. That's what I was saying. Is that it, that's not relevant?
I think I'm going to allow a bit of leniency, but I'm also going to, be cognizant of Ms. Bessner's time, but also her expertise and what she is actually here to give. So, Ms. Bessner, if you're receiving a question that you feel is not within the confines of this legislation, please, feel free to let us know that. Because there are questions that are being raised that I believe are not in confines with the legislation, and we certainly don't expect all our witnesses to be experts in everything to do with the law, because I don't think that's fair or reasonable, or it's appropriate.
The term that is used in this bill, new matter of significance, can include new information, new evidence, new law. New law can be a new matter of significance that could call into question the reliability of a verdict.
Okay. Thank you. That's exactly where I was going. If somebody wants to, if we want to expand on the relevance here right now, I'll actually bring it full circle, and that's to say this: if somebody was convicted of an offense in 1980 that would no longer be an offense today, or would be a different offense that attracts substantially lesser liability, and perhaps on the advice of counsel, that person didn't appeal in 1980 because they were told, you know what, look, the judge got it right. You have no hope. Or the person said, yep, I did it. I'm not going to appeal. I think that that's highly relevant and highly germane to what we are dealing with here today. And I've seen situations like this where people are convicted. I think we could probably go through the Court of Appeal decisions from the 1970s, and we will see people who went into a gas station with the intent to rob, and somebody died. There were a number of cases that were decided on this, and as parliamentarians, I don't think it's actually wrong for us to explore whether that person, whether or not they appealed, or whether that person, period, will have recourse through this commission, and whether the legislation, as it is currently written, would apply to give that person recourse. I see I've been going for a little while here, so I'm not sure if Mr. Van Popta was up next or who was up next here.
Thank you. Mr. Garrison, you're up next.
Thank you, Madam Chair. I would like to start by thanking Ms. Bessner for her comments on my amendment. All I will say is that it is drafted as a parallel exemption as was advised by the Canadian Bar Association when they're here, and there's no intention of that exception to affect the existing exemption in the bill. What I'm going to say now has to do with something which I believe is in order, so I'm anticipating objections. But I'm going to talk about why we should deal with this amendment before us today and the other amendments expeditiously. The chair has provided us an additional amount of time, which should be sufficient for us to deal with this small number of amendments. And I'd like to remind people we're dealing with a bill which all parties supported in principle at second reading, and a bill which all parties had the opportunity to introduce amendments if they had concerns about those sections. So I want to address two things here. One is that Mr. Moore continually says there's a robust process, and I'm at the risk of being a little repetitious. The process we have in place now is not robust. Since 2002, the minister has only recommended 20 cases for reconsideration by the courts as a result of the existing process. None of those were cases affecting women. Only one of those was an Indigenous person and one was a Black person. And I lay out those three categories because those are precisely the groups most overrepresented in our corrections system. And they're also the groups, because of their marginalization, that have been the most likely to suffer miscarriages of justice. So the existing system is not, in fact, robust and appears to be excluding from application consideration those who are the most likely to need that consideration. Now, my second point is that we're in a minority parliament, and the Conservative Party tonight has said it's clear their intention to force this consideration into the spring. And what that means is that we'll be back in this committee in February dealing with this same bill with the same limited number of amendments. It means that this is unlikely to get back into the House before March at the very earliest. We're in a minority parliament which could end at any time. And we have had years of work done on this bill. Certainly, I've been personally working on it as a member of Parliament for the last 5 years. I know that the former Minister of Justice, Mr. Lametti, worked very closely on this. We've had a broad consideration of these issues by very respected experts. And what I want to do right now is read into the record 4 letters which I have from people who have been observing this process, clause by clause consideration. I won't read them all in their entirety, but I think they're very important. And they have a common theme, and that is the concern that this years of work that's been done on creation of a new commission will be lost in this minority parliament if this filibuster continues. So the first is from Innocence Canada, co-president Ron Dalton and James Lockyer, member of the board of directors of Innocence Canada. And this letter has gone to the committee, but I'm reading into the record tonight with their permission, because the way the House of Commons grinds, it would be another day before this would actually be officially distributed to members, and there's obviously some urgency here. So the first letter from Innocence Canada says, and I quote, "All of us at Innocence Canada are extremely troubled by the events at the meetings of the House of Commons Standing Committee on Justice and Human Rights last week and this week, at which certain members of the committee have been filibustering clause-by-clause consideration of Bill C-40. It is essential that Bill C-40 be allowed to go to third reading in this session. Tomorrow's meeting of the Justice Committee, this was stated yesterday, tomorrow's meeting of the Justice Committee is the last chance for this to happen. Bill C-40, creating an independent miscarriage of justice review commission to review wrongful convictions, constitutes an immense improvement to our justice system, which is why we at Innocence Canada have been urging its passage for 31 years. There are women and men in our prisons for crimes they did not commit."
Point of order. Thank you, Chair. Chair, I, as the honourable member has previously pointed out with regards to my colleague, his comments are currently not pertinent to the amendment that's being discussed. So I would ask through you, Chair, that you would insist that comments are restricted to the amendment that is currently a part of our conversation right now.
So, thank you, Ms. Thomas. And of course, we do need to go back to the clause, and I'm going to allow a bit of leniency here with Mr. Garrison. He hasn't had a lot of chance to speak in the last X number of hours we've been sitting, and I think it's fair to speak to his amendment that he's put forth.
Well, Madam Chair, that's why I said at the beginning, what I'm speaking to is relevant. I'm talking about why we need to deal with this amendment and deal with this section in order to get this bill through Parliament. So I believe that it is directly relevant. Let me just skip to the last sentence here of the Innocence Canada letter. It says, to all those on the committee, please deal with the bill's provisions and vote on them tomorrow, and thereby fulfill your important duties as members of Parliament and members of the Justice Committee. I'll just read an excerpt from a second letter. This is from the Innocence Project at the Peter Allard School of Law at the University of British Columbia. Again, dated yesterday. After listening to the House of Commons Standing Committee on Justice and Human Rights hearings on Bill C-40, I write to express my deep concern that members of the committee are about to unravel the hard work of so many people over the past few years. Politicians, advocates, lawyers, law students, and more importantly, the wrongfully convicted and their families have all participated in consultations, attended meetings, and drafted detailed submissions in an effort to see miscarriages of justice remedied in a more efficient, more informed, and more impartial manner. In the interests of justice, I urge the committee members to pass at least Bill C-40 before the House rises for the winter. I won't read the entire letter. My third letter is from a group that appeared as a witness before the committee, and that's the Canadian Association of Elizabeth Fry Societies. And they write, we write today to urge you to pass C-40 before the House rises. Through this letter, we want to share the real and saddening consequences of witnessing intentional delays to the clause-by-clause reading of this committee's study on Bill C-40. And I thank members of the committee who are voicing support for the meaningful and immediate consideration of this legislation. And I'll skip again a bit of this letter. For everyone who has been watching every minute of these hearings, from organizations such as ours who support wrongfully convicted people, to impacted people themselves and their families, and to many others who care about Canada's approach to this issue, it has been deeply troubling to watch 3 full committee meetings proceed without movement. With the start of each meeting, we have watched, hopeful that members will act in good faith and put forward genuine consideration of the bill. And the last letter comes from a witness at one of our recent meetings who is from the University of Ottawa Department of Criminology, Professor Catherine Campbell, and is also associated with the Innocence Project Ottawa. And she says, and again, I'll read just a portion of it. I wanted to express my opinion to you as I was deeply disturbed to hear that the leader of the Conservative Party plans to shut down Parliament and not let legislation pass before you rise for winter break. I understand this could ultimately derail the passing of Bill C-40, which would establish an independent commission to address wrongful convictions in this country. I object strongly to this tactic, as it could, in due course, have an impact on whether this very important bill passes into law. And I'm going to skip just to the last. Given the enormous amount of time and effort that has gone into developing this bill, the many consultations before and after it was introduced in Parliament, and the fact that the Conservative Party has supported the bill at second reading, delaying at this point represents a very significant lost opportunity. So, Madam Chair, I believe we've had a full and extensive discussion of the amendment before us. I would urge members of this committee to take advantage of the extra time you've granted, yes, to raise their concerns as we move through this bill this evening. But really, as these 4 letters, and they're just a sample of the reaction from those in the legal community, and in particular in the miscarriage of justice community, have had to what they've seen in this committee, I think it risks bringing our committee and our Parliament into disrespect if we do not deal with this expeditiously. Thank you, Madam Chair.
Mr. Van Popta, you're on the list.
Good, thank you. I actually have a question for Mr. Housefather about his lib number 1, and I know we're talking about NDP number 1, but the two are so interrelated that I think they need to be discussed together, and I'm asking for some leeway there. So I don't know if Mr. Housefather, oh, you're still on the screen. So when I saw Liberal motion number 1, I was not surprised because this is what we heard Mr. Housefather say, I think was at the November 23rd meeting when Mr. John Curtis was with us. And this is the question that Mr. Housefather put to him. The thing that I'm most worried about in the legislation is the fact that you need to exhaust the appeals process I'm very concerned that the defendants we are looking at, Indigenous, Black, and marginalized people, are the least likely to have the financial resources and the least likely to have the ability to pay high-value lawyers to give them advice to continue appealing. Can I get the understanding of what in the UK is allowed in terms of the Commission's discretion to circumvent the exhaustion of appeals? I thought it was a fair question, and Mr. Curtis gave the answer, which I won't bother reading into the record. But remember when we heard Mr. Housefather put that question, I thought to myself, well, isn't the problem then that there's not enough legal aid at the trial level? Or is Mr. Housefather advocating for having an alternative system, one where the person who's been convicted doesn't have to pay because there's financial resources being made available? And in my reading, preparing for this study, I came across a UK case, the one that I think Mr. Curtis was referring to, although he did not give the citation. And I just want to read a paragraph from that case. And the case is called, it's Criminal Conviction Review, re Pearson. That's paragraph 8 that I'm reading from, about halfway through. And this is what Mr. Justice Bingham, Lord Chief Justice Bingham says. And it was a judicial review application of an unfavorable decision from the Commission. The main protection of the citizen accused of serious crime is, however, to be found in our system of trial by judge and jury. This system is so familiar as to require no description, but we draw attention to two characteristic features of jury trial germane to this application. First, the procedure is adversarial. There is no duty of the trial judge, as in an inquisitorial proceeding, to investigate what defenses might, if pursued, be open to the defendant, nor to interrogate or call witnesses. It is a function of the judge to direct the jury on the relevant law and to summarize, perhaps very briefly, the evidence and to define the issues raised by the prosecution and the defense, including any possible defense disclosed by the evidence, even if not relied on by the defendant. The judge need not and should not go further. Secondly, the decision of the defendant's guilt is made following a trial continuous from day to day by a jury assembled only for that trial, with no responsibility for the proceedings before the trial begins or after it ends. Thus, the decision-making tribunal must reach its decision on the argument and evidence deployed before it in a final once-for-all trial. So I just read that into the record because, we're all lawyers in this room, at least I think most of us are. And we recognize that the common law tradition of trial is an adversarial system. It's not an inquisitorial system. And it sounds as though Mr. Housefather's concern, and it's genuine, I understand that, is that some people are not getting a fair trial in that adversarial system because they can't afford a good lawyer. Well, then the problem is that there should be more legal aid so that people can get a fair trial. It's not to then have a commission fix all the mistakes that the trial judge made because the person couldn't afford a proper trial. Then I think that the answer is then to make sure that the trial is a better trial. And I would say this, and so I just want to add this, that the commission, according to this new legislation, is going to have investigative powers. So maybe Mr. Housefather is more comfortable with that rather than an adversarial system, to have an investigatorial or an inquisitorial system like in common law, on Continental Europe, where the judge actually gets involved in introducing evidence and being part of the investigation team. That sounds like that's where the commission is going, and I wonder if that's what Mr. Housefather is imagining that the commission is going to be. And I would add just one other thing, and that is we're talking about whether or not the whole appeal process should be exhausted. We had Mr. Varani here I don't know if it was the same day or, anyways, last month. And in response to a question from, no, it happens to be from myself, I asked him a question about whether the floodgates would open with this new commission and the new mechanisms. And he said, I think there are built-in factors to avoid them getting all the way through the floodgates. You still need to meet the threshold criteria. You need to have exhausted your appeals, at least to a Court of Appeal, or in some instances, all the way to the Supreme Court of Canada. So I really have two questions for Mr. Housefather, if he wouldn't mind to answer them. Number one,
I'll let you ask them, but I don't believe I'm going to let him respond until such time as if and when we get to his amendment. We're not dealing with his amendment yet, right?
so no, the problem I have with that,
He's not on the speakers list.
Madam Chair,
Fair point. Go ahead. Yeah, you can
Okay.
ask
Because
apparently
the
because
conflicting-
we need to make it's a line conflict and we need to make a choice between the two. So,
Exactly.
yeah.
One or other or neither, but it can't be both. Okay, so my question then to Mr. Housefather is twofold. Does he disagree with the Attorney General, who says that all appeals must be exhausted, because it sounds like his amendment will go contrary to that? And number two, how expansive does he think that this commission will be, and will it replace the adversarial system that we're so accustomed to? Thank you.
Were these all your questions, you said?
Those are my questions. yeah.
Okay. Mr. Housefather? Again, this is seeking
I'm going to-
clarification, and I'm told that's quite okay, but it cannot take, it depends on, the timing is
I'm
to
not gonna-
simply answer the question if you're able to.
Madam Chair, I'm not going to join the Conservative filibuster. I'm not going to be used to add to the time that they have to take up to avoid the question coming to a vote. But in terms of my comments, I'll repeat what I believe is that the exact same criteria should apply to a case that was not appealed to the Court of Appeal as is the case already in the legislation for a case that was not appealed to the Supreme Court, because the poorest and most vulnerable are the ones that wouldn't have the means or the legal help to appeal. So my amendment simply creates exactly the same criteria for a non-appeal to the Court of Appeal as exists in the legislation for a non-appeal to the Supreme Court. Thank you, Madam Chair.
Thank you, Mr. Housefather. Madame Michaud?
Merci beaucoup, Madame la Présidente. Je vais juste m'inscrire dans le débat rapidement pour dire que le Bloc québécois est en faveur du projet de loi C40, en faveur également de l'amendement proposé par le NPD, qui est un amendement important. Et je pense que les témoins ici présents ont pu répondre à la majorité des questions qui étaient toujours en suspens par rapport à la compréhension de cet amendement-là. Et je propose qu'on passe à un vote si personne d'autre a des questions, puis qu'on puisse aller de l'avant avec ce projet de loi qui est extrêmement important. Monsieur Garrison a lu tout à l'heure des communications qui ont été envoyées au comité, comme quoi plusieurs personnes attendent l'adoption de ce projet de loi-là, qui est extrêmement important. Alors, par respect pour ces personnes-là, je
Point
pense
of
qu'on
order.
pourrait faire le travail qui est devant nous. Merci.
Point of order.
Merci, Madame Michaud.
Le règlement. Vous êtes le prochain intervenant. Je n'ai pas pu obtenir une interprétation. Ça a été coupé pendant que Madame Michaud a parlé. Je n'ai pas entendu.
I didn't have translation either.
Apparently,
Just wait.
they were able to listen to it.
I didn't get it either.
He said it's on the wrong channel. Do you mind checking that?
Oh.
I don't know what that.
This is the English channel. I don't know if you can hear the interpretation.
I was able to hear it, so. Oh, you were not either. Okay. Whoa.
I'm on the English channel. It was fine. So,
You were able to hear it?
and
Oh,
I'm
my
communicating with them. It's all good. Now it's good.
Madame Michaud, est-ce qu'il y a quelque chose d'autre?
Madame Michaud, would you care to repeat or not? No, that's fine.
Mr. Moore, did you want to speak?
I do.
You had, okay. You don't have to.
No, I want to, and
I mean, you've spoken, that's why I'm asking, but, yeah.
yeah. Well, there's a number of questions that I have and comments on NDP 1 as well as on Liberal 1, since we're dealing with them both at the same time. And the first thing I want to point out, and there may be someone on the government side who could speak to this next if they want to. But the government, in its wisdom, Mr. Virani was here not long ago on Bill C-40, and they elected to have a requirement that a person have appealed their decision. The NDP 1 and Liberal 1 both do away with that requirement. It's no longer a requirement to have appealed your decision. So that's a fundamental change in the bill as it was received by this committee a short time ago, and as it was presented to this committee by the Minister of Justice. It's a fundamental change because in one instance, an individual would have been convicted at trial and then have appealed their decision, and presumably having had their conviction upheld, would now avail themselves of the commission. That would be the bill as proposed. The bill as amended, should NDP 1 or Liberal 1 be successful, would eliminate that requirement that an individual would have appealed the decision. And I guess my question, Ms. Besner, is if the department has done an analysis of the international situation. I know we had testimony here from the UK as well as from North Carolina. North Carolina has a very it was interesting. North Carolina is the only state in the U.S. that has a commission like this. So, of all the many states, there's only one that has this commission. But it was interesting to be able to hear from an individual from that commission who gave testimony that factual innocence was the bar by which somebody could avail themselves of the commission. There has to be a finding of factual innocence, and there's quite a high bar of entry to the commission. One of the bars of entry on our system, as proposed by Bill C-40, if amended, as proposed by Bill C-40, was that an individual has to have appealed their decision. That's showing some degree of faith in our system, and I have to agree with what Mr. Van Popta said. It's we're trying to address. Certainly from my perspective, address issues around someone who is innocent, someone who was convicted of a crime they did not commit. That shouldn't happen in any country. It shouldn't happen in Canada, that someone be convicted of a crime they didn't commit. However, being humans, we fail, and everyone can get it wrong within the system. The police could get it wrong, the prosecutor could get it wrong, the judge could get it wrong, because we're all human. Therefore, when new evidence arises that an individual did not commit the offense, that they were wrongfully convicted, as has happened in many high-profile cases in Canada, there's a process in our country that individuals avail themselves of relief. So my question is, in the international experience, when the department drafted this legislation and provided advice to the minister, of course, the minister presented the legislation to us, the government chose to maintain a requirement that an individual would have appealed. These two amendments fundamentally alter that, and I want to ask, and if you don't know, that's fine, but I want to ask if there's been a comparison with any international peers on this requirement that an individual has to have appealed.
Thank you, Mr. Moore. Ms. Mesner, I'm not sure if you have an answer to that, but
Well, we're aware that in the UK, they have a provision in their statute whereby the Commission can make exceptions. It's a very short provision. I don't have it with me, so I can't read from it, but it's just exceptions can be made. I just wanted to point out that currently the criminal code does require that appeals be exhausted. I think that when I was here with the minister on October 31st, I might have explained that the way Bill C-40 sets out the exceptions and the considerations is a codification of the relevant law that explains how it's to be considered and applied. In the past, there was some confusion as to what it could include and not include, and so the approach was to just clarify. And so that's what's in C-40 there with the list of considerations for whether exceptions can be made for the Supreme Court level. I would add one more thing, just for information for the committee. In sub 3A of the provision we're looking at here, it says the Court of Appeal has not rendered a final judgment on appeal of the finding or verdict. So those terms are lifted from other parts in the code, and that's for drafting reasons that they were used. But I just wanted to share with the committee that in the case law, in a decision called Albin, the courts have clarified that if an applicant on an appeal has requested an extension to file an appeal and been denied, or has filed for leave to appeal and that's been denied, that constitutes a final decision of the Court of Appeal. So it doesn't mean final judgment, that there was actually an appeal heard and a decision rendered on the merits of the appeal itself. It's just that the person attempted to seek an appeal and was unsuccessful.
thank you.
Okay, then looking at the UK, thank you for your answer. This ties into these amendments because when we look at the UK situation, and we have to look at other countries and how they handle their commissions, and that's why we had witnesses from the UK as well as from North Carolina. But with the UK Criminal Cases Review Commission, powers and practices. Legal powers mean we can often identify important evidence that would be impossible for others to find. We can interview new witnesses, re-interview the original ones. If necessary, we can arrange for new expert evidence, such as psychological reports and DNA testing. We look into all cases thoroughly, independently, and objectively. But the legal rules that govern the work of the Commission means we can only refer a case if we find there is a real possibility, and this gets to the crux of my point, there's a real possibility that an appeal court would quash the conviction, or in the case of an appeal against sentence, change the sentence in question. That real possibility already puts our system, the test that's being proposed in C-40 is that a miscarriage of justice may have occurred. May have occurred is an incredibly low bar. Of course, a miscarriage of justice may have occurred in a case. We have to aspire to something more than the absolute floor. And to suggest that someone can avail themselves of a commission, a new commission, that I'm hoping nobody in this room would want to create a parallel justice system or clog up our courts with cases that shouldn't be before them, cases that have already been dealt with. But, you know, if you're in a situation where you've been convicted of a crime, you've appealed your sentence or not, and you have a chance to have that sentence overturned, why wouldn't you take it? So that's why in the United Kingdom, to avoid any frivolous, I should mention, even with this higher threshold, in the United Kingdom, when this commission was opened up, they saw a rush of individuals who sought to have their convictions overturned. So they have set a standard. We brought them forward as witnesses, but our standard is far lower. So now, the effect of NDP 1 and Liberal 1 would be to further lower the threshold whereby someone could avail themselves of this commission. So they say that only refer a case if there is a real possibility that an appeal court would quash the conviction or, in the case of an appeal against sentence, change the sentence in question. The Criminal Case Review Commission is a prescribed body under the legislation dealing with the making of public interest disclosures, whistleblowing. That means that quite apart from their statutory responsibility to deal with the applications they receive, they're a body to which individuals can report concerns of actual or potential miscarriages of justice. So what it takes to refer a case for appeal is new information plus a real possibility. And neither of those things are requirements under existing Bill C-40, let alone if we were to adopt NDP 1 or Liberal 1. Neither a new information or real possibility are requirements that would bar someone from availing themselves of this commission, using up the commission's time, perhaps having clogging up the justice system, when the conviction doesn't even have to believe, the commission does not even have to believe that there is a real possibility that a miscarriage of justice has occurred, or that there's a real possibility of an appeal court overturning a conviction. It's a two-part test, as we heard, and it introduces this very reasonable, I think, test. One, is there a real possibility that a miscarriage of justice occurred? If you accept that, two, is there a real possibility that an appeal court would change the sentence? What they're trying to do there is ensure that they're dealing with cases where, on the evidence before them, they believe there was a miscarriage of justice, number one. Number two, based on the evidence they have, whether an appeal court would overturn that sentence or would not offer a conviction when there has already been a conviction. So they go on to say we must be able to show the appeal court some new information. Again, that's not a requirement of C-40. That was used at the time of conviction or first appeal, and that might have changed the outcome of the case if the jury had known about it. It will not be any use simply to apply to the CCRA saying that the jury got it wrong when they choose to believe the prosecution case instead of the defense, unless there's a conviction showing new information to support the idea. And I don't want to narrow in on that. It will not be any use simply to apply to the CCRA saying the jury got it wrong when they choose to believe the prosecution case instead of the defense. That's how our system works. Unlike some of the wrongful convictions that are most famous in this country, we now have the Charter of Rights. We now have an improved legal aid system. We have a justice system that affords those charged with incredible rights. And we've heard testimony on other pieces of legislation, like the Bill C-5 and others, the fallout on Bill C-75 that have said, there's individuals that are being let out that should be in jail, or there's people that are not getting convictions that should get convictions. We've heard from victims say that we don't have a justice system, we have a legal system. So the cards are oftentimes stacked against victims in this country, and that's what's lost in some of this debate. But I have to refer back to the UK system, and their commission is one that we've chosen to take a strong look at, that simply saying, I didn't get a fair shake, I don't agree, the jury got it wrong or the judge got it wrong, and I'm actually innocent, that is not good enough to avail yourself of the commission. So what they go on to say is, for us to be able to refer a case for appeal, we must think the new information is convincing enough that it raises a real possibility that the appeal court will overturn the conviction. If we refer a sentence for appeal, we must be convinced there's a real possibility that the court will reduce the sentence. And this goes to something that Mr. Caputo raised about changes in sentencing guidelines, individuals that were convicted of an offense in the past, that it would not be the same level of offense now. They can, in the UK, avail themselves of for a reduction in their sentence, but they have to be convinced that there's a real possibility the court will reduce the sentence. So, Madam Chair, what they go on to say is most people apply to the commission because of convictions or sentences they have received in Crown Court. And they go on to reiterate that standard of, first, new information, and second, a real possibility. So I go back to C-40 that was presented to us by Minister Virani. Number one, does C-40 say there has to be a real possibility that a wrongful conviction occurred or a miscarriage? No. Bill C-40 says that it may have occurred. Even under our current legislation that the minister currently exercises control over, there's a higher standard than may have occurred. Of course, it would be impossible to have a lower standard than may have occurred. So one thing I took some comfort in with C-40 when it was originally presented is that there was this requirement that an individual would have at least availed themselves of an appeal. Madam Chair, there's a tremendous amount of noise on the other side there, and I don't know. I know you're listening, but it's not fair to you when you have your colleagues talk. I know you want to hear everything I'm saying, but...
Pardon me?
Excuse me, everybody. I think Mr. Moore has the floor. So,
okay.
As much as we can, we'll Mr. Moore, go ahead. And I do have the earphones because I am, for whatever reason, I'm finding it difficult to hear anybody because maybe it's just so much repetitiveness that although I'm doing my utmost best, but I do have the earphones and I have them on pretty high. So please,
Point of order,
continue.
Madam Chair.
Monsieur Lezon, oui.
C'est juste, j'étais en train de parler avec ma collègue.
I was discussing with my colleague, and I was wondering if the witnesses are here, and they're filibustering, and we're retaining the witnesses here. We might go on for quite a while, and I was wondering, quite simply, it was a bit unreasonable for the treatment we're giving to our witnesses. I mean, they're our guests here today, and I find it very untoward. Well, that's all that we were discussing. Perhaps they need a health break, you know. How about we have a health break right now? So, let's think about their welfare as well. Thank you. 5 minutes. We're going to suspend for 5 minutes.
Allow people to use the washrooms and grab something to eat. Thank you very much. And yes, of course, yes. Yeah. Thank you. Continue with your if you have questions still, do you, or you have more to say?
Do the witnesses want time, Madam Chair, to finish their meal?
But I'm not sure if Mr. Moore has any.
No, thank you, Madam Chair. I was talking about the UK system and their standard as it relates to NDP 1 and Liberal 1. And that real possibility standard. This is seen as a lower bar than Canada's current threshold. And if I was to ask everyone around whether they know what Canada's current threshold is, I don't know if they would know. But the current threshold requires this: a conclusion that a miscarriage of justice likely occurred. So there's within the criminal, and this ties into NDP 1 and Liberal 1, but within our system we have beyond a reasonable doubt. That's the highest standard that we use. That is the standard by which someone needs to be convicted. Is beyond a reasonable doubt that they committed the offense. It can't be that they might have done it, or there's a good possibility that guy did it, or on the balance of probabilities, 50-50, I think he did it. That's not the standard that we use in Canada. The standard that we use is beyond a reasonable doubt for conviction. A lower standard applied in civil cases is and some other cases is on a balance of probabilities. That means you weigh the scales and you say it's more likely scenario A than scenario B. That is a balance of probabilities, a balance of possibilities. Probability, sorry. But this, the Canadian standard right now under wrongful conviction, current law, requires a conclusion that a miscarriage of justice likely occurred. When you consider these different standards, Madam Chair, that's a fairly high bar. That to say that it likely occurred, the minister has to feel that that they feel that there was a miscarriage of justice. It's not that there may have been. It's not that there's a real possibility. This is a very high, a somewhat higher standard. It's not as high as the Criminal Code standard of balance of beyond a reasonable doubt, but it's that it likely occurred. The UK standard is that there's a real possibility that a conviction would not be upheld. Real possibility is a far lower standard than our current standard of likely occurred. This different standard helps to explain a much higher volume of cases that are successful in the CCRC, that's the Criminal Cases Review Commission of the United Kingdom, versus those in Canada's criminal conviction review process. So we're talking about, depending on how many you're counting, we're talking about a minimum of 3 standards here. One is our current standard that a miscarriage of justice likely occurred. The other is the UK standard of a miscarriage of justice. There's a real possibility that a miscarriage of justice occurred. Then there's the new standard in Bill C-40. And the new standard in Bill C-40 is that a miscarriage of justice may have occurred. And that's why, Madam Chair, I have real concerns about NDP 1 and Liberal 1 and reconciling those and explaining how this wouldn't open up an absolute tsunami of applications. And depending on, these are very subjective tests, depending on how the Commission chooses to operate, we could have a ridiculous volume of frivolous cases with that standard. I'm not suggesting necessarily that the current standard is the appropriate one. The current standard is that it likely occurred, which I take that to mean the minister feels there's at least a 51% chance that that there was a miscarriage of justice. The UK standard, to me, is more reasonable, and that's why later on, once we've dealt with NDP 1 and Liberal 1, and I'm not speaking to it now, but later on you'll hear of we've moved a Conservative amendment that that would change that standard from may have occurred to the UK standard of likely occurred. I think that's completely reasonable. I think that will protect this commission, protect the Canadians' perception of our justice system. I was looking at some polling, and I'd encourage all members to look at the polling on how Canadians feel about our justice system. And it's pretty dismal. You know, Canadians are really concerned about our system of justice in Canada. They want a top concern is that the rights of victims are protected, that individuals that should be behind bars are behind bars. So we have to be very careful. In Bill C-40, we have to get it right. And at the outset, when I speak to NDP 1, it ties in directly to this standard of a miscarriage of justice may have occurred. So on the CCRC, the UK Commission, the idea of a Canadian CCRC obviously has significant support amongst experts, stakeholders. Some people argue it's potentially too costly. Canada has a low number of identified wrongful convictions. And you could take that to mean a couple different things. One, you could say we're not finding enough wrongful convictions. The other you could say is that our system of justice is effective at preventing wrongful convictions. I mentioned some of the safeguards that we have in place. I think it was Mr. Caputo. No, it was an individual that Mr. Caputo had recommended as a witness, a former associate of his, who spoke very highly of Mr. Caputo, but he brought to the attention of the committee. I found his what was his name?
Mr. Viberg?
Yes. He had some very interesting testimony, and he was reminding committee members that the landscape around our system of justice has changed remarkably since some of the more high-profile cases around wrongful convictions in this country. The coming into effect of the Charter of legal aid, DNA evidence. DNA evidence didn't exist at a time of some of these wrongful convictions. DNA evidence can be used to convict. DNA evidence can be used to exonerate. And I need to speak about the North Carolina experience, where I wouldn't want anyone to be under any illusion that what's being proposed here in any way is in sync with what North Carolina has done once we've heard that testimony. North Carolina, they require evidence of factual innocence. And I asked the witness from North Carolina, why did you come up with that standard? And she said, well, that's the standard that we found would be acceptable to the people in North Carolina. And I have to believe, from talking to my constituents about the justice system, which I do, and hearing from other members of Parliament from all parties on what they hear from their constituents, I have to believe that Canadians' expectation around wrongful conviction more closely mirrors what North Carolina has proposed versus what is being proposed in C-40 should it be broadened. And that is that there is new evidence to suggest that is likely that someone who was convicted of an offense was innocent. Every single one of us should want that person to be completely exonerated. If that person is found through DNA evidence or other evidence is found to have been wrongfully convicted of a crime they didn't commit, and we heard the example. You remember the case with O.J. Simpson, where he immediately said he was going to go out and look for the person that actually committed the crime. Well, most people thought that they had the person that committed the crime the first time, but that's the kind of response there should be when there is a wrongful conviction found within our system. It should be that strong that it should be that strong that Canadians would say, we need to find the person that really did this. That is not the standard that is in Bill C-40. So why do I mention that? Because Bill C-40 is tenuous enough with the, I would say we do need to have a system, obviously a robust system for individuals who've been wrongfully convicted. We have a system now. The Minister of Justice is ultimately responsible for that system. We have a threshold now that says that a miscarriage of justice likely occurred. We could debate around this table whether that is too high of a threshold. But what I can tell members is that if we were to poll our constituents and say, well, what should the standard be? They would be much more likely to say that the bar should be that there's a real possibility there was a miscarriage of justice, rather than an individual's convicted, they don't appeal their sentence, and then they can avail themselves of a commission. And what standard does the commission apply? Well, there may have been a miscarriage of justice. Based on new evidence? Not necessarily. Based on the whims of the commission at that time. That is where we're heading. Should C-40 be amended and broadened in its scope? So I think that went in. I'm not going to put anyone on the spot. I'll answer my own question. When the minister and when the cabinet considered Bill C-40 before it was tabled, and on the advice that they would have received from departmental officials, there's a reason why an individual, except under exceptional circumstances, had to have appealed their decision. There's a reason inherent in that. There's a reason why that standard is meshed with that requirement. The ultra low standard is that miscarriage of justice may have occurred is requires that step of having appealed. To introduce the possibility of not appealing at all then calls into question even further the low threshold. So it's for those reasons I do have concerns with NDP 1. We did a study recently as a committee on the federal government's obligations of victims of crime. And I think of that study often when I look at other pieces of legislation, because that's a lens that I hope we should all agree, that's a lens that we should somewhat look through. That's a lens that should always be on our mind, that when we look at any piece of legislation, and right now I'm looking at Bill C-40, specifically NDP 1, and I want to look at Bill C-40 and NDP Amendment 1, I want to look at that through the lens, at least, of victims of crime. What does a victim of crime say about a process whereby if someone feels they were wrongfully convicted, even though under this law, under this provision, they may have committed the offense, a process that's going to involve dredging up the the concerns that that victims have and having victims re-victimized. And I don't throw that out lightly. The process re-victimizes victims. That's why we need to get this right. We heard that testimony at this committee. We heard that we heard that from victims who have lost loved ones when they said, having to go to parole hearings, having to know that my daughter has to go to a parole hearing when I pass on, my daughter will go to a parole hearing of the individual that murdered my husband. We heard that testimony. That re-victimizes victims. Victims have been through enough. So when we create a system that could amount to a reopening of these very hurtful cases for victims, we better be sure that we're dealing with cases that we ought to be dealing with. And that is why we have a system of justice. I think it was Mr. Van Popta that rightly mentioned that some of the fixes that people are trying to incorporate into this catch-all, some of them may be rightfully placed in other areas. For example, access to justice, legal aid, making sure that we have, this question was put to Minister Varani, making sure that vacancies in the system of judges are filled, making sure that people can get a hearing, making sure that there's timely access to justice. The old expression, justice delayed is justice denied. All those things. This commission cannot be a fix-all for everything that's wrong in the justice system. This commission should be about the wrongfully convicted. And I fear with NDP 1, we are steering away from that principle and into a area that I don't think Canadians would be supportive of, and that is the possibility of opening up a parallel justice system, whereby it's just another avenue to avail yourself when you've been charged and convicted with a crime. You may choose, well, I'm not going to appeal my sentence as I'm supposed to do. I'm convicted. I'm not going to appeal. I'm going to try out this new commission. And what's the standard for that conviction? Commission? I know within the criminal system, the standard is beyond a reasonable doubt. Within this system, the standard is a miscarriage may have occurred. So, I look at. I was speaking a bit about victims. I look at the UK treatment of victims and what they say, and I think this is instructive for us. The CCRC, a reminder, that's Criminal Cases Review Commission. First off, the CCRC has been criticized for not having objective standards to determine the scope of investigations, with neither a minimum amount of investigation required nor a logical endpoint to the open-ended task of proving the absence of error. So, they have their challenges too, even with their higher standard. But it was clear from the testimony they take that investigative responsibility serious. When it comes to victims, the CCRC will not contact a victim just because we're looking at a case. And listen to what they say. This is because most of the cases we look at are not sent for an appeal. Why? Because their standard is that there's a real possibility that the conviction would not be upheld. Their standard is not that the conviction may not be upheld. There's a real possibility. We know that victims and their families have already had stressful experiences. Finding out their case is under review can make them feel they're having to relive it all again and are not believed. We do our best to avoid causing unnecessary distress where we can. That's the UK. They're saying we're not going to put victims through a frivolous. They're acknowledging that a lot of the cases, the applications that come to them, they're not going to hear them because they have a standard. And they're saying we're not going to put victims of crime through this just because someone says, hey, I didn't get a fair shake. I was wrongfully convicted. I'm going to take a shot at the CCRC. They say we don't even notify the victim right away because They don't want to stress out the victim and their family. They know what this will put them through to hear that the person that was convicted of maybe murdering a friend or a family member is now going to suggest that they were wrongfully convicted. If the CCRC decides to send a case for an appeal, we will always try our best to tell the victim or their family. If the victim or their family feels we have not acted in accordance with our policy, they can complain using our complaints procedure. Our customer service manager will take an independent look at the issues raised. So I haven't heard from the NDP or the Liberals on how they reconcile because if I had seen a two-part amendment, if I had seen an amendment that said we don't want to require appeals, however, we do agree with having a higher standard, had I seen that, I might be wanting to take a closer look at the amendment. However, there's a reason why the Minister of Justice had the requirement to appeal, and for those reasons, I would urge extreme caution around both NDP 1 and Liberal 1 because they do not mesh with the full context of the bill that has a extremely low access point of a miscarriage of justice may have occurred. So I think I'll wrap up my remarks for now on NDP 1. I have some questions that I am going to put to our witnesses that are here, but I might save that for a bit. I just wanted to make some comments early on to everyone, our committee members, as we deliberate on NDP 1 about the UK experience, because what I mentioned was not part of the testimony that we heard. That is through some deeper digging that I had done on the UK experience, and I find it incredibly compelling and instructive. Their concern around victims, their rationale behind their higher threshold, the fact that even with their higher threshold, they were met with an enormous volume of applicants. And we have to be prepared for that too, that we are going to have an enormous volume of applicants. And unless we want to completely ignore the entire UK experience, and they have years of experience on this, unless we want to completely ignore their rationale and their lived experience by having a commission, we are not only going to face an enormous volume of applicants, but we're going to cause enormous disruption to victims and their families if we don't get C40 right. If the threshold is too low, this is going to cause enormous hurt to families of individuals who were killed, injured by those that have been through our justice system and have been convicted and not even having appealed that conviction. So I'll conclude my remarks on that note on NDP 1 for now.
Thank you, Madam Chair. I'm just going to go through NDP 1 here now. I'm going to just go through it here a little bit. And so what I see here is that at the outset, it speaks about replacing line 35 on page 2 with the following. So it would read, again, I do this because I sometimes have difficulty placing it in unless I read the whole thing together. So it would say, for the purposes of subsection 696.4 sub 3, the application must include information indicating whether the person's rights to appeal the finding or verdict have been exhausted, and, if they have not been exhausted, information relevant to any factors that the applicant believes should be taken into account for the purposes of the subsection. Now, as it currently reads now, is relevant to the factors referred to in subsection 696.4 sub 4, and those subsections are under 696.4 sub 4, and I'm looking at page 3 right now, the amount of time that has been passed since the final judgment of the Court of Appeal. So if I understand the NDP amendment, it actually would remove the requirement to consider these things. So the amount of time that has passed since the judgment for the time of appeal, I think that's quite relevant. The reasons why the finding or verdict was not appealed to the Supreme Court of Canada. Now, we have heard a fair amount of evidence. We've also heard a number of submissions from members of this committee as to why or why not something may have been appealed to the Supreme Court of Canada, why or why not something may have been appealed to a provincial court of appeal. Again, I do think that that's probably a relevant factor, though, as to why we should be considering whether or not something, whether this legislation or whether the commission should review the application. Next, whether it would serve a useful purpose for an application to be made for an extension for a period within which a notice of appeal or a notice of application to leave, as the case may be, to be filed for the Supreme Court, may be served and filed. Now, this is an interesting point here on sub 4, sub C. And the reason I say that is this. We have talked about legal aid and its lack of funding. Now, ultimately, whether a decision is appealed, that final say rests with the accused, who is obviously going to be the client. A lawyer can't put forward an appeal if their client does not wish to put forward the appeal. So it's obviously quite relevant, but this is interesting to me here because what this is saying is, should we be considering whether this person who is claiming that a miscarriage of justice has occurred, whether it would serve a useful purpose for an application to be made for an extension of period of time? And I wonder whether provincial legal aid bodies would look at this provision and take heed of it and say, look, when we are dealing with something that is a potential miscarriage of justice or an allegation of miscarriage of justice, that we will appoint counsel in order to seek extension of time to appeal. Because the mischief, as I understand it, that NDP 1 and that Lib 1 are addressing is the fact that some people wouldn't have appealed because they didn't have the means, if I understand it correctly. That's one of the issues. Well, what about if subsection 4, subsection C, is really an exhortation to say to legal aid in the provinces, look, you should be funding these appeals, in which case seek leave to appeal, seek leave to extend the time to appeal, and then seek to appeal, right? Because then we are actually looking at whether a court of appeal, they may say on the basis of the appeal, there is no need to go before the commission. We have to remember that the Court of Appeal is the mainstream process. Everybody who's in the room knows that when somebody is unhappy with their decision, that they have the right of appeal. That is the main way that things are done. So this is actually quite a revolutionary piece of legislation when we think about it, because we're establishing a commission that will be appointed, will have commissioners appointed by government who don't necessarily, as I recall, need to have a legal background, right? So this is a parallel set of proceedings. So the question of whether a person should have to have exhausted their appeals and whether that should be material, I think is quite a live issue, especially if the provinces, reflecting on what we've had to say and listening to what Mr. Housefather and Mr. Garrison have had to say, look, people may not have had the ability. Should the recourse not first be to the Court of Appeal? Because that is the whole point of our system, is that when you have been aggrieved, when the court below got it wrong, you go upstairs, we would say, right? You would say, time to go upstairs to the Court of Appeal. So I find that interesting, and I wonder whether we should be circumventing the necessity for an appeal. And I wonder, I'm just thinking out loud here, whether an amendment could actually be made and whether there might be, I'm just trying to think about the cases that relate to the funding of appeals, especially if there's a bona fide potential for a miscarriage. If somebody shows that they have a bona fide case that there may have been a miscarriage of justice, not even a high threshold, because we're not talking about overturning the appeal. We're talking about the appointment of counsel to simply help somebody to appeal. I don't think anybody around this table would say, you suffered what could have been a miscarriage of justice 30 years ago. You did not have the means to appeal it. Therefore, this legislation not only will establish the commission to do it, but it will also establish a mechanism by which you could pursue that in a more streamlined manner. I'm not sure. I'm not going to ask the experts to comment on it because I know that that's not an easy thing to do, given that my thoughts on this are still kind of coming together. But
Point of order, Madam Chair.
Mr. Garrison, yes?
In light of some of the comments that Mr. Caputo has made, I believe there may be an error in drafting my amendment. I'd like to withdraw my amendment in favor of Liberal 1.
Okay, thank you.
That's amazing.
Okay, well, I take it everybody agrees to the withdrawal of the amendment. I guess that's what I'm hearing.
Point of order, Madam Chair.
No point of order. I'm asking. Yes.
And I'm making a point of order.
Yes.
Just for clarification, Mr. Garrison, once the amendment is moved, it becomes the committee's, I think. So we would have to agree to
Yes,
him
I'm
withdrawing.
asking. That's what I'm asking. That's what I asked.
should we have a chat for a couple of minutes? Is that possible? This is pretty
Yeah, well, I can give you a couple of minutes. I mean, obviously, I'm thinking you're very happy with that. That's what you. Yeah. No. Okay. No. Certainly. Yeah. No. Take a couple of minutes. Yes, I'll suspend for 2 minutes. Go ahead. All right, we're back, calling meeting back to order, please. I'm calling a vote on the suspension. Mr. Clerk, would you please go ahead and do the vote? Not on the suspension. On the withdrawal of the, so,
Madam Chair,
Yeah.
point of order.
yeah,
In light of, I mean, normally we meet 3:30 to 5:30. In light of the time, in light of the fact that it's taking a long time to get through these, and I suspect it will continue, I would make a motion that we adjourn the meeting at this point.
well, do you take the vote? Okay, Mr. Chair, please go ahead.
Because Mr. Garrison asked.
Oh, I can't do that. I have to deal with, I'm sorry, I have to deal with the withdrawal first. There's no objection to it. Okay, so we have unanimous consent to withdraw that. Thank you very much.
Madam Chair, on the, there was much made about how long the meeting was scheduled for, and
So
that our witnesses are
now I'll
here.
deal with,
And
the a different point.
That's why I'm moving
Okay,
a motion. Normally, we meet from 3:30 to 5:30. We're heading into Christmas season. We're not going to pass Bill C-40 tonight, no matter what, because there's too many clauses to go through at the rate we're going. We're scheduled to meet in the new year, I think, on January 30th or 29th. So I would suggest that we adjourn now and everyone have a Merry Christmas, and then we get back to work when the House reconvenes. Motion to adjourn.
Okay, so we have a motion on the floor to adjourn. We would like to have a recorded vote. I hear you, Mr. Maloney, and I'm going to ask the clerk to please take over.
On a motion to adjourn, Mr. Maloney,
No.
Madame Brière,
No.
okay. Mr. Mendicino, Mr. Mendicino, on the motion to adjourn. Should I continue, Madam Chair?
Well, we can come back to him.
Okay, we'll come back then. Mr. Housefather,
No.
Madame Dillon,
No.
Mr. Moore,
Yes.
Madame Thomas. Oh,
Oops.
I don't have a.
We
I
don't have
a
your name.
substitution.
Just we don't have a substitution.
Good. Mr. Caputo.
So what do you do?
Mr. Van Popta? Yes. I don't have it here.
You have to vote.
Okay, back to Madame Thomas.
Clerk, I think if you seek it, you'll see that he's actually officially subbed in, and I am no longer.
I'm on the mailbox here. I didn't receive anything.
So, Ms.
Unless-
Thomas, you're here. Do you mind getting this over with?
Okay, I just got it. Okay.
No, it was sent.
You said- okay. Okay. Mr. Genois then.
Yes.
Okay.
Mr. Mendicino.
Madame Michaud,
Mr.
En faveur.
Mendicino's there.
en faveur. Mr. Garrison,
Yeah, I know.
you go back to Mr. Mendicino.
Yes, please.
Going back to Mr. Mendicino.
No.
Okay.
Oh, oui.
Yes, yeah.
Did you ask? Madame Michaud?
Madame Michaud. Oui, oui. Oui. Madame Michaud said yes. Okay.
What was he? You read his mind. He said yes. He wants to adjourn.
What?
You don't ask us.
I have 6 yea, 5 nay.
Hold on here.
5 nay, yeah. Nay 6, nay 5.
So we're adjourned?
This one here, Madam Chair.
Okay.
So we have 5.
6 years, 5 nays.
6 is more.
Merry Christmas, everybody.
Six yeas, 5 nays.
I think you should get clarification.
The motion is carried.
Where is it?
You cannot do this, clerk. Clerk, you're responsible for calling this vote.
Mr. Mendicino,
Yes.
okay, I know you're acknowledging that I'm speaking with you.
No. This is BS. You can't do this. This is an attack on the rights of members of parliament. He cast his vote. You're not going to get away with
Madam
this
Chair,
nonsense.
Madam Chair,
He cast his
follow
vote,
the
you call
procedure.
vote. No, we're not going to play these games.
You're the
okay?
one playing the games.
No. He voted. You can't just sit here in the middle of the vote because you don't like the result.
Ask him if he voted.
Call the vote, clerk. It's the clerk that calls the result of the vote.
Does he doesn't have his thing either.
Well, we should be here.
To clarify, I was acknowledging I vote no.
Oh, what is this? This is not allowed. You can't just sit here and wait for the change of the vote until you get what you want.
D'accord.
Suspend the second.
So go ahead.
Yeah.
Clearly
Suspend
didn't
a second.
participate.
If you need to, go ahead. Do I suspend
Yeah.
it?
This is not going to fly. This is not going to fly at all. You should respect the rules of the committee and adjourn.
Let's take a second, please.
In the middle of the vote, you're suspending.
Well, it's not.
It's not complicated.